So you've probably seen the format. Two of my colleagues have had some sessions with your colleagues in the last couple of weeks, and we're doing a roadshow, if you like, with various antitrust regulators across Africa. And the purpose is really just to give both antitrust practitioners, competition law practitioners, and businesses a flavor of what's going on from a policy and enforcement, legislative developments, as we've sort of discussed. And so I think we have about 30 minutes, if that's fine with you, and really want to get a sense of the sort of 3 or 4 broad themes that I wanted to chat to you about. The first is the current merger regime in Mauritius. We know it's a voluntary regime. We will talk a little bit about developments in the pipeline, but current state of play, there are guidelines issued about when merging parties should consider notifying the agency. You have, I think, your combined 30% market shares, or if one party has more than 30% market share, the guidelines contemplate or suggest or recommend parties should come and voluntarily notify that merger. I want to get your thoughts about the regime generally. Do you feel that companies are in fact notifying transactions where they meet those thresholds? Can you talk us a little bit about your experience in terms of instances where the agency has gone to go and investigate transactions which haven't been notified but have now been implemented, and merging parties are at risk of potentially having remedies imposed, post implementation? If you could give me a little bit of background about what your experience has been in the last couple of years and what the current trends are.
Yeah, surely. First of all, let me thank you for organizing this very interesting initiative and for having given us the opportunity to be part of this advocacy initiative. So as you rightly said, Mauritius is one of the few countries whereby we do not have a mandatory notification regime. So notification is voluntary. So it is up to the parties to decide whether or not they will notify a merger transaction to us. Initially, I must say this was quite challenging for us. We were not really having a lot of notification. In our initial years, we were having on average 1 notification per year. At times, we were even not having 1 notification. And thereon, we tried to conduct several advocacy initiatives to convince companies who are party to merger and acquisition to come and seek our guidance on those transactions, more so when the companies are of sizable dimension or they have important market shares. Despite that, we were not really happy with the number of notifications we were having. So lately, we set up what we call a merger intelligence or merger detection mechanism here. So through that mechanism, now we can detect nearly, we can say, most mergers which are happening in Mauritius. So, we have intervened in quite some number of cases. And where we have intervened, we have tried to advocate it. As they say, enforcement is the best advocacy. So I must say now we have seen an increase in the number of notifications. This year we have nearly 4 notifications already. So as compared to 1, it's quite a lot of in terms of improvement. But still, I must say we are still conducting several inquiries, which is equivalent to phase 1 assessment on transactions which were not notified to us. Meaning we still believe that there is room for improvement in the number of notifications that we receive. And obviously, our detection mechanism basically is able to identify mergers, mostly when they have already occurred. And this is not the ideal situation to be intervening when the merger has already been consummated. So it may be challenging at times, both for the merger parties and us as an authority to implement effective remedies. And for merger parties also, this would be more costly. They have already merged. Now we are asking them to divest assets, etc. So I believe that although we are trying, we are able to manage with it. This is not the ideal world. It is not optimal for us, nor for parties who are part to a merger situation. Obviously, we'll come on how we are trying to address this issue. as I said, we have tried to intervene where there was need to. We have got quite some merger notification recently on which we are still working. And there have been cases whereby there was need for us to impose direction, obviously. As most competition authorities around the world, insofar possible, we try to engage with parties where we feel there is need to, where we identify any anti-competitive effect of the mergers. And I must say 90% of cases we are able to sort of find what we call an undertaking together with the merger parties to address the concerns that we have. But there have been cases whereby there was need for us to impose direction, where we were not able to arrive at a consensus with the parties. There has been a case where the parties were not agreeable with undertaking. We were not able to arrive to a consensus on the undertaking, and whereby the transaction itself was abandoned. And recently there was a case whereby we have imposed direction, whereby the party was required to divest one of its enterprise as a condition to proceed with the merger. So this is briefly. I don't know where you want to.
No, absolutely. I want to pick up on this merger detection task team that you've established.
Yeah.
What are some of the tools that they are looking at? I mean, is that task team? Where are they getting their information, their data from? Are they scanning what other agencies are doing, transactions that have been notified in other jurisdictions? Because this will be particularly interesting, I suppose, to our international friends and clientele.
Yeah. Well, I cannot disclose all our secrets, so basically I will tell what we can. So basically we have set up a detection mechanism which comprises of various elements which we use as input to that mechanism. And one of our main, let's say, element of that system is a collaboration with other regulators, other public bodies who have information on mergers and acquisition. And through that collaboration, we have developed an internal software here as a Competition Commission, which enable us to sort of identify changes which are happening at shareholding structure of different companies. And these data are pulled into the system. And then on a weekly basis, we run a report through the system to give us a list of companies whereby there have been changes in their shareholding structure. And this is used as an input to our system. Then we conduct what we call a screening exercise. Obviously, we're not interested in every change in shareholding or ownership structure. So we try to identify companies which are of a sizable dimension and whose market share may be of interest to us. So out of this screening exercise, we identify those transactions which we want to further dig into. And this goes to another phase of our detection mechanism. So I must say through that mechanism, we are able to identify on average about 300 transactions per month. So this is quite important for us.
Very. And you said you've identified or you screen sort of certain companies which are significant players in the market. Do you also have priority sectors that you are particularly keen to assess for a variety of reasons?
For mergers, I won't say that we have any priority sector. In general, we have priority for proactive detection for, let's say, monopoly and other market studies. But for merger, we do not really prioritize sectors. But as and when they come, we identify them. So basically, if there was a need to sort of scan particular sectors, then maybe the issue of prioritization would arise, but now we are able to sort of identify nearly all transactions. So we do not really prioritize in terms of sectors, but in terms of size of the transaction mainly.
Okay. Yeah. Very interesting. And so let's talk a little bit about procedural issues. Assuming somebody notifies a transaction, they're above the market share threshold set out in the guideline, but it's a raise no competition issues, a vanilla type transaction. What are parties looking at from a timeline perspective to get the authority's approval?
Yeah. So once we receive a notification, we have 30 working days to give sort of the phase one. So within 30 working days, we will come back to the parties and give them our initial view. So as it's not a clearance in itself, either confirms the parties that we do not have reasonable ground to believe that it would affect competition, or if we believe that the transaction may affect competition, then we will inform the parties that we are proceeding to phase 2. So basically, if the transaction is not problematic, they can expect an answer within 30 working days. And for problematic transactions, then within that 30 working days, we will start to engage with the parties. So we try to be as business friendly as possible, obviously. So we'll try to engage with the parties to inform them of our concerns and invite them to consider undertaking. As I said, in most cases, parties are willing to consider undertaking, and then we'll use what we call the undertaking route, in absence of which we'll conduct a normal phase 2 assessment. And for phase 2, our guideline states that we have a maximum of 6 months. But in most cases, we are able to complete that before the 6 months, and more so if we have undertaking. So basically, if we have undertaking, we can complete it before the 6 months. And upon the completion, we produce a report which we send to the commissioners for their decision, for their determination. And this one is up to the commissioners. I cannot, there's no specific timeline as such in itself. It will depend on case to case, whether the parties have given undertaking, whether the parties are requesting a hearing, etc. So in brief, this is a process.
And so because at the moment it's a non-suspensory regime, merging parties should, within at least the 31st 30 days, at least get a good sense of whether something like a divestiture might be a reasonable remedy. And if it's not a divestiture, if there are other undertakings, behavioral undertakings, parties could probably still comfortably implement their transaction while you engage on behavioral type remedies.
But when there's a notification, we expect the parties to put some transaction on hold.
Okay.
Yeah. And you will see the guideline clearly specifies, our law clearly specifies that parties may seek our guidance in relation to intended mergers. So they are not mergers which have already been completed. So one of the requirements would be that the merger has not yet been implemented. And but there are circumstances whereby we can engage with the parties in exceptional circumstances, I would say, whereby we can arrive at a sort of a consensus of arrangement, if possible, in relation to any urgent matters that need to be completed.
Yeah,
but this would be exception. Yeah.
Yeah. No, I'm thinking more in the context of multi-jurisdictional filings that are time sensitive and need to close. So you're saying there's a willingness to engage on bespoke transactions, hold separates, or other types of arrangements.
Exactly. Yeah.
Okay. Well, that's useful to know. The report that goes to the commissioners for determination, I assume there's no opportunity for parties to make representations before the commissioners. That they make their representations to the investigatory team who prepares the report, and then that report goes to the commission for determination. Or is there an opportunity to engage, present evidence, economic and oral evidence at the decision-making level?
Yeah, they have both opportunities. So during the investigation, normally we will send what we call a statement of issues within the early stage of the investigation. Basically, there we detail what are our very initial views, what are our concerns in relation to the transaction. So the parties would be invited to provide their views on the statement of issues. And where we have nearly completed our investigation, we issue what we call a provisional finding report. And once more, we invite the parties to give their views on the provisional finding reports. And it is only after having the comment and views of the parties that we issue a final report. So basically, the final report will contain our assessment, the views of the parties, and what are our views on the views of the parties. So it would be quite detailed. And nonetheless, together with our recommendation to the Commission, what should be their stand. And nevertheless, the parties will have the opportunity to make additional representation before the Commission. So The law provides that where the Commission intends to impose a direction, they have to hear the parties. So if there has been no undertaking and the Commission intends to impose directions, they will have to hear the parties. And in any circumstances, the parties also has a right for a hearing before the Commissioner. So it is quite flexible. It is quite, in terms of process, the parties' rights are quite protected under the law. So they can make representation during investigation and also before the Commission.
You mentioned a recent merger where conditions were imposed. That's, of course, the Engen Vitol transaction. Is that a transaction? Can you give us very briefly? I know it's published in, I think, the Commission's latest newsletter. Very briefly, what were the key hallmarks of that case or features of that transaction from a Mauritius perspective that led to conditions being imposed?
This was quite an interesting case. The Vivo Engen case. It was in fact notified to the COMESA Competition Commission. We were simultaneously conducting an inquiry here on that particular matter, so a phase 1 assessment. And we started to engage with the parties, and they informed us that they will eventually notify the COMESA Competition Commission. And once the COMESA informed us about that they received a notification, so we were of the view that that particular transaction did have an appreciable effect on Mauritian market. So in Mauritius, there are 4 main players in the petroleum sector. So basically, we have Vivo, Engen, we have Indian Oil, and Total. So Vivo is by far the largest player. And we were concerned that following this transaction, the market will from 4 to 3, right? And in terms of market share, there were several markets in which the combined market share of Engen and Vivo would have exceeded the 50% market share. And if you see our guidelines, there's a presumption that a merger is problematic if that market share is exceeded, unless there is obviously evidence demonstrating otherwise. So consequently, we asked the COMESA Competition Commission to refer the matter to us. Most of that the transaction affected different markets in Mauritius. So in terms of market, we had the retail supply of petrol in petrol service station. We had also the sector for marine fuel. We had the sector for jet fuel. So these were the main sectors that were affected through the transaction. So, and it was quite tricky in terms of type of remedies that was needed to be imposed. For example, if we see marine sector, what was important in that sector were infrastructures that were owned by these companies, and not only the market shares that they have. So it was important for us to understand which asset, which tank, which pipeline they have as a port, and how that would affect the transaction. So as we are able to really gauge the effect of the transaction in that particular sector. So we felt that the transaction had a very local dimension for the intervention. So that's why we also referral, and eventually the COMESA Competition Commission agreed to refer the matter to us insofar that it concerned local markets in Mauritius. Then obviously we started to engage with the parties until we arrived at a consensus on a potential undertaking. Basically, the parties agreed to divest Engen, the local entity in Mauritius. So basically, they would acquire Engen in South Africa, and on the conditions that they divest all their shares in Engen Mauritius. There were certain assets that they were willing to take, which we believe that would not be significant in terms of effect on competition. So we agreed to that. And now they're in the phase of implementing that undertaking. So basically to find an independent purchaser of Engen, obviously with the approval of the Commission.
Thank you. I mean, one of the themes I wanted to explore with you was the relationship that your agency and authority has with various other agencies, both, of course, the COMESA member states, the COMESA Triple C, but also other international regulators. And I think it ties also probably into your earlier remarks about your merger detection unit. To what extent, both on a formal, informal basis, is the Mauritius Competition Authority Commission interacting with other regulators?
Well, we must say we have quite a very good relationship with most regional and international bodies. Insofar as that it concerns COMESA, we work very closely with the COMESA Competition Commission, as you just said previously. So the COMESA organized a training in Mauritius for judges. So this shows a collaboration that exists between the two authorities. So we also collaborate with the COMESA not only in terms of cases, but also in terms of capacity building and training. So recently, the COMESA sent some delegates from Congo to Mauritius for training. So we agreed with this collaboration. So we hosted them in Mauritius on 2nd May. We also collaborate on cases whereby we have that engagement. As I said, there have been at least 2 referrals that were agreed with the COMESA, which shows that we can work together in a collaborative manner when there is a need to. And there have also been cases whereby there were impact on Mauritius, but we discussed with the COMESA Competition Commission how they can deal with the matter at their level. For example, there was acquisition of Mobilac Industries by AkzoNobel. So in that particular case, we did not ask for referral, but we work in collaboration with the COMESA, and the COMESA Competition Commission engage with the parties for undertaking. So it's more about which is more efficient. So we are very sort of collaborative on this particular angle. As you may also be aware, we also work with different regional and international competition authorities. So we have good working relationship with most of them. So in Africa in particular, we work closely with South Africa. We also are part of several informal networks. So as you know, in Africa, we have the African Competition Forum, in which Mauritius is a current chair. So this shows our involvement in such a type of, I would say, informal networking. In the ICN also, we are very active. So basically, we are co-chair in the ICN Merger Working Group, whereby we participate in different projects, and we are leading a project for that working group. We also have very good work relationship and collaboration with more, I would say, experienced and sizable agencies, for example, with the European Union. Just now, we have one of our senior officers over there for a secondment of 3 months. Which shows once more the level of collaboration. We have also engaged with the European Commission in the past concerning cases whereby obviously with proper consent from parties, we have discussed with the European Commission on substantive matters of cases. One such case was a merger between Ocimel and Lafarge, which was also assessed by the EU. So I would say we have a very high level of collaboration with both regional and international players insofar it concerns competition.
Excellent. Moving quickly then to what I think is on everybody's minds, the bit of crystal ball gazing as to what the new Mauritius merger is going to look like. We know it's on track. We know it's coming. We know there's, I think, quite a bit of collaboration with COMESA, Competition Commission, who themselves are going through a legislative reform. I know it's a little bit early and premature, and you might not be able to speak in detail on issues which are still up for finalization. But can you give our listeners a sense of what are some of the hallmarks of what this new regime might look like?
Yeah. As I said, so currently we have a voluntary merger notification regime, which we believe is not the optimal mechanism for at least Mauritius. So one of the main changes that we are considering is to introduce a mandatory merger notification mechanism in Mauritius. So obviously we are advocating that to legislators. So we have quite advanced in what we are doing in terms of a revised law that we intend to propose to the legislators, which will cater insofar it concerns mergers and acquisition for a mandatory merger notification regime, obviously, which would be subject to turnover and asset thresholds. I cannot reveal all the secrets of the new law. So basically, for mergers, there will be mandatory merger notification regime. And as I said, we we are trying to keep a proper balance between the need for a mandatory merger notification regime and also not to overburden the business community. So as I said, we try to be as business friendly as possible. I guess
can I ask whether things like obviously financial thresholds are key, and what type of turnover gets utilized for calculating those thresholds. Those are always important, but are there discussions about how foreign to foreign mergers are going to get treated? Are there, for example, like the Nigerian competition regime, where there are simplified procedures and then they had expedited procedures and all those types of mechanisms to try and ease to encourage multi-jurisdictional parties to come file in Mauritius without feeling that their deal is going to get held up. Are those types of discussions taking place? Or those, I don't know if it's going to be included, but is the agency giving some thought to those practical type of issues?
Yes, obviously. So I guess we have tried to draft a law which is quite unique, I would say, and business friendly. So it gives certain flexibility to us in terms of deciding on which mergers may be exempted, for example, from the duty to notify. We also have catered for possibility for simplified notification mechanism, which would be part of the new regime, so not to delay mergers which are not problematic mainly. So in brief, it would be, I guess, a mechanism which would ensure that we have a good perspective on mergers and acquisitions, while ensuring that we are not overburdening the business community and not requiring notification which are not required to or which are not problematic.
So I've given you some flexibility to answer that question, but my next question I want you to answer, and I'm going to hold you to your answer. When is this going to be implemented?
I must have the crystal ball to tell you it's not within our purview. Well, I can say we have quite advanced in terms of process. We have nearly drafted a quasi-final draft, which we will now consult stakeholders on. But thereon, it will depend on a process which is sort of outside our control. So we'll basically have to seek the approval of legislators, which is a different process. So very difficult for me to say, but hopefully it won't be long.
Okay. Yeah. First half of 2025, is that a realistic expectation? Or is that
25 would be
2025?
Yeah, a target for us.
Okay. I want to use the remaining minutes to discuss unilateral conduct as well, which you oversee. There've been some investigations. We've spoken to your colleagues about market inquiries, but I'm interested particularly on the enforcement side or potential enforcement side. Can you give us a little bit of an update as to what you're busy with and what your department is busy with in the context of unilateral cases and investigations?
Yeah. Well, maybe you have gone through our law for unilateral conduct also. So we have also a quite unique regime for unilateral conduct in Mauritius. For example, we don't have fine. Abuse of monopoly is not prohibited under the law. It's reviewable by us. So basically, you can review, and after review, if there is need, we can impose direction as provided under the law. Our ambit on the type of directions that we can impose is also quite unique around the world. So it's quite broad, I can say, in terms of discretions that we have. So currently, we have quite some cases which are ongoing. Some are being challenged in court. So basically, we have one case that we just launched is about exclusivity agreement in the sector for cigarettes. So cigarette is quite regulated sector in Mauritius. So advertising is not allowed, promotion is not allowed. So this makes the market quite difficult in terms of entry. And incumbent players would have obviously an advantage on the market. So one of the main players in that market, which has significant market share, has put in place exclusivity agreement with certain of its distributors, which we are investigating currently and which we believe may obviously have an effect on competition. So we are at a very early stage of the investigation. So, and the firm conclusion can only be drawn upon completion of the investigation. We have also, I guess for the first time we are doing it, we have launched an investigation in exploitative conduct. So basically for mobile data tariff. So whereby we believe that two operators were practicing at least excessive prices. So these two cases are being challenged in the court because the parties are arguing it's a regulated sector and our purview on that is limited. So the matter is in court currently, and we are waiting for their decision to clarify this issue of whether we have an ambit on a regulated sector and to what extent we can really look into conducts in that sector. We have some further cases we have just launched, and they are not public yet. So basically, when a party has expressed it is willing to provide undertaking, we try to engage in the undertaking before making that transaction public. So these two cases that we have currently are on the route of undertaking, so they are not public. So at this particular point in time, we have, I would say, 3 + 4. We have 6 ongoing investigations into potential abuse of monopoly situations.
Excellent. And are there any amendments on the cards, legislative amendments dealing with unilateral conduct?
Yeah, obviously we are considering once more to align ourselves with international best practices and what we believe would be an optimal regime for Mauritius. So currently there are no fines for abuse of monopoly. We believe this is a shortcoming under the law, and it becomes very easy for firms, so we abuse, and if ever we get caught, we change the conduct. No risk. So we believe it's not optimal. So we are considering to introduce financial penalties for abuse of dominance in Mauritius. So this would be part of the amended laws that we intend to propose legislators. This would be one of the main changes. We're also considering to change our guideline. So mainly in terms of how we deal with exploitative conduct. So to bring certain clarity to the business community on what will be our approach insofar it concerns exploitation of monopoly situation.
So for companies who do hold a dominant position in the Mauritius market, and now knowing that there is law that's going to come, probably more stringent law with greater consequences, and might want to relook at their trading terms, their contracts, would it be fair for them to sort of look at European, COMESA, South African guidance, ICN type guidance as to what type of conduct would typically be objectionable? Do you think that would be a fair steer until we see the final law, if someone wants to get a head start?
Yeah, I guess we have benchmarked ourselves with international best practices, and those would be initial guides for those who want to take a proactive stand in compliance. But in any circumstance, we will not take companies by surprise. So we anticipate that we will conduct advocacy, whereby we will try to inform the companies of the new law and how that may affect them in terms of their conduct, how they can be more compliant. And obviously, there would be guidelines, there would be different advocacy initiatives. I guess that we'll revise our own guideline to make it clear to the business community on what would be permissible under the new law and what would not be permissible in the new law. Yeah.
Excellent. That makes absolute sense to me. Sailesh, we've come to the end of our session. Thank you very much for making yourself available to speak to us. I have no doubt our audience are going to find this all very, very helpful. And so I appreciate your time. Thank you very much. And we look forward to further engagements.
Thank you very much. See you. Bye-bye.
Bye-bye.